From then onwards, stage by stage, we have been reforming our laws, our investment environment, and the various treaties that we have had for the purpose of encouraging investment. Now, we were 130 in the ease of doing business till recently, but at least 8 separate reforms attracted the attention of the World Bank. And on a review, we have been raised to the position of number 100. Now, this is only at the first instance because I don't think that we can be very proud of being 100. Now, to be attractive, we have to have a large number of various steps that we have to take. One, we have to have laws which are just, fair, and reasonable. An independent judiciary, which of course we have. Speedy justice, which we don't have. And legal representation according to the choice of the litigant. Now the last thing is the one which is lacking. Because so far as international investments are concerned, it comes with the need for arbitration. The need for the foreign investors to have their own advisors. And some or other, I think the Bar Council of India has not been looking at it with the same amount of concern which other nations have. For example, you have the institution known as foreign legal consultants in all the countries. They are a separate category. They are the practitioners of law from foreign countries who want to practice law in the country which is a host country. They are permitted to practice only their domestic laws or their home country's laws. They are also entitled to practice international law. There is a separate discipline which is drawn up for them. There are rules of conduct which separately apply to them. They have to register. They have to show their proficiency of in laws, practice of laws of their own countries. And they have to show also that they have reasonable clientele of their own countrymen who would want their litigate counsel. Now, with all these conditions, they are permitted. But India is not permitting them. However much this matter has been discussed again and again for the last about 15 to 20 years. Delegations have come from England, of lawyers, of the Law Society. Attorneys have come from the American Bar Association, has come from the United States, and they have been pleading their case, saying that, look, we have our clients. They have come to India. They are setting up industries. They are having joint ventures. They are bidding for huge projects. But at the same time, you are laying a bar. And therefore, in those circumstances, you should consider what we have been doing. Many of the states have been having these foreign legal consultants. Japan has been having. European countries have been having. And therefore, why are you not allowing us? And therefore, this is an impediment. And we have to realize it. For we have to have the same system of foreign legal consultants who are permitted. Now, the matter came up to the Supreme Court recently. And the Supreme Court held that the maximum that will be permitted is for them to fly in and fly out, which would mean that, so far as they are concerned, they would be entitled to appear in arbitrations and then leave the country straight away. Now, this I don't think is a very satisfactory state of affairs at all. If you want to attract foreign investors who have to have the lawyers of their choice, and therefore it would the Bar Council of India, according to me, would do well. And I think so far as the various law firms are concerned, they themselves would realize or should realize that it is in their own interest to have foreign lawyers coming in, advising their own clients, not advising Indian clients, but also advising Indian clients if they want to, but only as in regard to their domestic law, the foreign law of their own country, the law of their own countries, or international law. because that is what is permitted by all the countries. Now, the laws of the rules of discipline in those countries are separately applied to, as I said, these foreign legal consultants, and therefore it is quite unfortunate. I remember, so far as the lawyers in the TataSky courts are concerned, some or other they came to feel that their business would be taken away. And they went on a big procession to prevent foreign lawyers from coming into India, because they said that they will be taking away their business. Now, I think it requires a very brave foreign lawyer to come and appear in any of the subordinate courts in India, or even in the high courts. I would welcome any of them coming and arguing, so that I know that we can learn from their knowledge of law, their presentation of cases, presentation of arguments, and so on. It will be of mutual advantage to those lawyers as well as to... Now, the judges sitting here would say that they know that we are very prolix in our arguments. We go on and on to put forward one narrow point. We repeat it 10 times perhaps, I don't know. You will have to ask them as to what they think about it. But what is seen from their practice is they are very precise. For example, for drafting submissions to be presented to the Supreme Court, the draft is corrected again and again at least 6 to 7 times before it takes its final shape. So far as the words are concerned, the word is picked out, thrown out, and the apt word is put in. Again it is removed and another, the more apt word is put in. This is the amount of effort which is put in, and that is what we can learn. And they're very brief, very concise, so that within half an hour the entire case is put over. But the reason for that is also because the judges there have far more leisure. They take, for example, the US Supreme Court, they take only about 100 to 110 cases a year. And the 111th case, which raises a very, very important issue of federal law or constitutional law, the judges, after consulting among themselves, they say this is a very important case, but unfortunately, we will not be able to do justice to it because our dockets are full. Therefore, we will listen to this case and take up this point when it occurs in some other error which we come across, because we do not have the time, nor is it our function. And therefore, they will deal only with cases where the matter is of very great importance, far-reaching national importance, and therefore they would have to deal with it. Therefore, this is one aspect which... Can I have a glass of water? This is one... this is a chronic problem with me. A bad throat, which is an essential equipment, I think the most important equipment for a lawyer. Now, this is one of the aspects which I thought I will touch upon. Next, arbitration. So far as arbitration is concerned, we have improved tremendously. I think previously we were having mainly ad hoc arbitrations. Even now, ad hoc arbitrations rule the entire scenario of arbitrations in India. But international arbitrations require a totally different environment, a totally different approach. Why is it that India has not been able to be a successful center for arbitration? Now take Singapore, for example. The SIAC, the Singapore International Arbitration Center. Now, that is now a very, very busy center of arbitration. They had 2 years back only about 74 or 80 cases. Today they have 364 new cases on their file. And you'll be surprised to know that a very large section of these cases are Indian cases where the Indian government is involved. And the Indian government finds that there is no center for arbitration in India which they are able to satisfy the foreign party would be an institution of excellence. Now, unfortunately, we have not been able to build up international centers for arbitration. About 15 years back, and I was one of the founding members, also Fali Nariman was there, many of us were there, the International Center for Alternative Dispute Resolution was started. And it is hoped that this would be an attractive center for international arbitration. Also, far as at least Indian government's cases are concerned. And mind you, the Indian government, the government of India, has very, very heavy cases where at least $1 billion are involved in some of these cases where the gas disputes, the coal disputes, and so on. Now, in such a case, we find that we have to either think of London LCIA, we have to think of the ICC arbitration, we have to think of the CIAC, and so on. Now, the government of India had invested 80 crores in setting up a fantastic infrastructure. But unfortunately, that center was used for lectures being given, foreign trainers coming in and training people in mediation, arbitration, conciliation. But no cases whatsoever of any importance, a few handful of cases. And therefore, for the last 20 years, it has really been stagnating. And the Supreme Court of India, at one stage, I think Chief Justice T.S. Thakur decided that enough is enough. And they said that we will take it away from the existing rulers that may be who are running the ICADR, and an agreement was arrived at. But according to me, it would not be appropriate for the courts to run arbitration or be in charge of arbitration centers. But more than that, it will not be appropriate for the government to run arbitration centers, because people will not have confidence if government is a party. There is also the one which decides upon who the arbitrators will be, who drop a panel of arbitrators. And as a result of it, you have to think of a third entity. And that will be an independent body of persons of excellence, experts in arbitration, very good juries, who will ensure that the ICADR serves a purpose which the Singapore Arbitration Center has taken away from India, as it were. I do not mind that happening, because if we are not able to supply the needs of international arbitration, then I do not think that we should grudge them going to where there's a lot of similarity in culture, and it is perhaps closer than very many other centers like London or New York or any other place. Therefore, I think it is time for us to sit back, think on these two aspects at least, to ensure that so far as India, I can't say regains, India becomes a center for international arbitration, at least so far as our cases are concerned, where there is an Indian entity which is a party, where the government of India is a party, and if this happens, then I think that so far as we are concerned, it will be a catalyst towards international investment, foreign investments coming in greater India. That's what I said earlier about foreigners being permitted to freely come to India, but under that separate regime of what is called a foreign legal consultants. Thank you.